I'm Jason Gunter, board certified labor and employment lawyer, downtown Fort Myers. Today I want to talk about the term wrongful termination. So we get a lot of phone calls from clients, or we talk to a lot of employers who say either, I believe I've been wrongfully terminated, or Jason, I'm going to terminate an employee and I don't want to get sued for wrongful termination. Okay? You go on the internet and you type in wrongful termination and you'll get a whole bunch of definitions about precisely what wrongful termination is. So what is a wrongful termination claim, or what is a wrongful discharge claim under Florida law? I want to talk about that and really talk about what that is. Before I do that, I think it's important for everybody to understand the basic legal principles of employment law in Florida. Under Florida law, Florida has instituted what is called the at-will doctrine. And what that means is that as an employee, if you do not have a contract for a specific duration, you may be terminated at will anytime, with or without notice, or with or without cause. That sounds pretty harsh, but that's the reality of not only Florida law, but nearly every state in the nation. Likewise, if you are an employer and you have an employee that you want to terminate, you can terminate that employee without liability at any time, with or without cause, or with or without notice, without that having to worry about that employee bringing a wrongful termination claim against you. So for example, if you are an employee and you got in an argument with a coworker and the employer conducted an investigation and they didn't conduct that investigation fairly, and they made the decision to terminate you and retain the other employee. Well, unless it's discrimination based on a protected status, even though that employer may have handled the investigation improperly, even though that employer may have not conducted a complete and fair investigation, your termination does not give rise to a legal cause of action. So you're probably wondering at this point, how do I make a living? What exactly is a wrongful termination claim? There are various statutes, both in Florida and under federal law, that give an employee certain rights. If an employee is terminated in violation of any of these statutes and the employee can prove that claim, that employee has a claim for wrongful discharge under that particular statute. Let me give you an example. Florida has what is referred to as a whistleblower statute. That statute says that it is unlawful for an employer to terminate an employee because that employee has objected to or refused to participate in a policy or practice of the employer that is in violation of a law, rule, or regulation. So if an employee objects, as I just defined that statute, and that employee can prove that he or she was terminated because of that objection, then that employee would have a legal cause of action for wrongful termination under Florida's private sector whistleblower statute. Let me give you another example. Under federal law, Title VII of the Civil Rights Act of 1964, which is the law that prohibits discrimination in the workplace, that statute has anti-retaliation provisions in it. So if you are an employer and you have an employee who comes forward and complains that they are being sexually harassed by John in the break room, and if that employee subsequently loses their job after they have made that complaint of sexual harassment, that employee may have a claim against you for retaliation or wrongful termination under the anti-retaliation provisions under Title VII of the Civil Rights Act of 1964, or Florida's comparative law, which is called the Florida Civil Rights Act. So those are two examples of what are many examples. The work comp laws prohibit an employer from terminating an employee in retaliation for that employee having brought a workers' compensation claim. The Family Medical Leave Act, which applies to employers with 50 or more employees, prohibits discrimination or adverse actions against an employee because that employee has taken protected leave under the Family Medical Leave Act. And there are many statutes that could conceivably apply, too numerous to name in one video session. So what you need to do if you are an employer is, depending on the size of your company, is to make sure that you have somebody that is advising you on these things or has a good understanding of these things, so you don't end up with a wrongful termination claim. The best time to handle a wrongful termination claim is actually before it happens, is to take some type of preventative action to make sure that that employee is not wrongfully terminated and the situation is handled correctly. So when I have an employee who comes into my office, for example, and they want to know if there's a wrongful termination claim, I want to know all of the facts. Everything. I want to know the dirt. I want to know whether or not you have objected to policies or practices of the employer, complained of illegal conduct, been discriminated against, had a workers' compensation claim, been injured, taken leave because of a birth of a child or because of a serious health condition of a family member. I want to know all of those things because I want to be able to properly analyze that case and determine whether or not there's a legal case, and if there is, I'm gonna bring it. So that's what wrongful termination is in a nutshell. Again, to go over all of the statutes would be time consuming. Maybe I'll go over them each individually in the future. So if you have any questions about that, whether you're an employer or employee and you just want to call me and talk about that, I'd love to talk to you. My name is Jason Gunter. I'm a board certified labor and employment lawyer, downtown Fort Myers.